All right, good afternoon, everyone, and welcome to our Compliance Insights Roundtable. My name is Pierre Simon, Managing Director of Simon Consulting and your host for today's session. Joining us today to discuss this important topic are two renowned experts in the field, Elizaveta Palaznik and Marcel Thiess. In our previous roundtable, we discussed the practical aspects of preparing for a MiCA license. Today, we will further elaborate on the challenges and opportunities presented for crypto asset service providers. As always, we encourage you to actively participate by sharing your questions or comments in the LinkedIn comment section below. Our experts will do their best to address them either live or through the comments once the session concludes. So, of course, last month, guys, we had a very interesting roundtable, a lot of questions that came in, and today we want to go a little bit deeper. So maybe, and I think one of the main feedbacks we got, right, Marcel, is if we can get a little bit more practical, provide a little bit more practical examples on what are the challenges faced by, currently registered CASPs to actually become MiCA licensed. So maybe we can kick off with starting with an example. Marcel, would you like to start?
Yeah, sure. That was actually one of the many good feedbacks that we've received and I received was really to provide more concrete examples that are more relatable, and so people can get a better sense of what it actually means to become MiCA compliant. And one of the examples that I immediately thought of was a client that I had recently that was asking me to help them become compliant and implement and closing the gap really for their conflicts of interest rules, their internal ones, and how to be fully compliant and taking into consideration also the guidelines, the RTS that was released, right? And I think this is also a great example of how you should and can work with this regulation, because MiCA lays out in Article 72 the general requirements, and then you need to read the RTS really to get a sense of the actual requirements on how to go into the implementation phase. And I think that's where most people get stuck, and that's also the part where I'm most involved, because people are not sure about the next steps then, right? So how to actually do it. And in that case, me and the client, we really assessed what specific needs are there, what measurements do we need to take, and do we need to engage any third-party tools or provider in order to become compliant? And I think one interesting part is there are certain definitions like connected persons, right? These are spouses and anyone really who could have a conflict of interest. The whole rules even cover outsourced entities to some degree, right? So it's quite broad. And then these connected persons, right, whomever they are in your case, you need to make sure that you record and document their personal transactions. Specifically mentions personal transactions. So this was interesting because the question then was, so how do we do that? How do we track these personal transactions, keep a record, and be able to show proof to anyone requesting it? And there are also the requirements to share and display conflicts of interest, right? So in this particular case, we actually came down to two different solutions. One was using an internal accounting setup or software, whatever you want to call it, to adjust it slightly, and then have these persons that are caught by this share their wallets, disclose them to compliance, and then keep track of their transactions, and so use that as a solution. It wasn't feasible, so ultimately they ended up engaging with third-party providers who are slowly preparing for this, even for this tiny specific request. But since MiCA is broadly and is basically pretty similar to other regulatory frameworks and pretty similar to MiFID II, you could have also checked some of these requirements prior even to the RTSs, but some things are slightly different with MiCA, right? I think that's also important. Some things are even less detailed in MiCA that are more specific in MiFID, but that's something I wanted to cover on a later point. But yeah, that was just one example that I had. I've many more actually, but that was one of the things where we really had a very specific article, then did a deep dive, saw the requirements, assessed what needed to be done, figured out that there isn't a solution yet or not a feasible one, and then finding a solution to that, right? And this whole process took 1 or 2 weeks just for that tiny bit.
Yeah, I think that's a really good example, and I think there might be many, right? And I think during our last roundtable, we touched upon different topics, more high level. We touched upon AML, we touched upon DORA. Maybe we can dive in a little bit deeper on that as well. But I think these practical examples are really useful. And I also like that you linked it also to MiFID, because of course there are a lot of similarities if you look at MiFID compliance and MiCA compliance in regards to conflict of interest, market abuse, and any other related topics. I think definitely a good example. Lisa, do you have any nice examples to share with us?
Yes, I mean, my approach is more, I would say, general methodology, because depending on the clients and in which stage they are, of course, the approach will be different. So usually what I start with, the question I'm answering, is part of my first stage. I will call it the regulatory strategy development. So this is basically the first question for you to ask yourself as a CASP or even as a financial institution. Do you actually need a MiCA license, or is there another route to this compliance? Maybe if you're already a financial institutions, you will not need the authorization per se. You will need maybe just to be compliant and just to notify the National Competent Authority. So this is one road to have. If you already have a MiFID license, for instance, you can also provide some similar services you're providing in the traditional financial sector as well. So if you maybe have some already licenses, you might leverage those licenses to be MiCA compliant without going through this MiCA authorization process. So this is the first question I would say we figure out together is, do you actually need to go through this authorization process? Depending on the license you already have, your maybe future services you're planning to sell as well. Where are you based as well? So many different aspects to just reply to this question. Do you actually need one? Because we talk a lot about you need a MiCA license, but actually maybe it's maybe not that I would say efficient for you, or it maybe not make sense for you to go to that route. So you have different possibility, and this is the first, I would say, step. And if you do actually need a MiCA license, then the question is what type of requirements you should comply with. You have a lot of them divided if you are offer to the public of tokens or IRTs or EMTs, or if you're a CASP as well. So, and within the CASP section, you have different types of services. Then some CASPs, they have basically a general obligation to comply with, but then you also, as a CASP, you will need to comply to some specific requirements depending on the service you provide. So basically the second step is to identify all the requirements you need to comply with as a CASP, as the service you provide. So this is require an analysis from myself of, okay, what services you provide, basically your product analysis of your product governance, basically of the service you provide today, but maybe in 6 months you're planning to launch something. This is something we need also to take into consideration to then discuss this with the regulator as well. So this is the second step, where basically I scrape all the requirements of MiCA and I put them in a nice Excel file. And to this, basically, we will start a gap analysis, because that will give you, the next question would be for the CASP to know, okay, what is my situation? Maybe I'm already compliant, maybe half compliant, maybe not at all. And this I've noticed, if a CASP has this essence or have a background in the financial the traditional financial industry, they already have this essence and reflexes of compliance, of risk. They already have. So the work that needs to be done is less important than the one that doesn't have those reflexes, if you understand what I'm saying. So then the point of this analysis is really to know what is the extent of the work that needs to be done, is because then comes the implementation phase. So in order to know the time length of the project itself, you need to understand the extent of the work. And in order to know the extent of the work, you need to do this nice gap analysis of all the requirements that the CASP specifically need to comply with. So not all the CASP, your specific business. And then to basically do a gap analysis to see what are the stakeholders that are impacted, and to see what are the actions that are already into place, and what are the things that needs to be put into place, that needs to be done in order to bridge the gap. And this will give a quick overview of, okay, that will take us 6 months to update the policies, the different standards, the tech policies, the tech implementation as well, because you might have some policies that needs to be updated, but also technologically speaking, you might have some updates also to do as well. So I think the first stage is really to have an overview to evaluate how deep will be the work. And this stage, depending, of course, on the CASP, on the people already working there, if they already have the right reflexes, might take a couple of months just for this first analysis of development strategy of, okay, we need to do this, the requirements are those ones, and then this is what you have today, and this is what you need to have tomorrow. So this work is basically already a couple of months, and then from that we decide, okay, you already actually maybe 60% compliant, 3-4 months extra, and then you'll be ready. So the total will be maybe 6-7 months. But then again, depends on each CASP. The work can be more or less done. Then the second step is, of course, the dialogue with the regulator constantly during the implementation phase. And then we can actually start implementing once those gaps are identified. So this is basically the whole scope of, in a very 5 minutes nutshell, what is required. Some companies, they don't need everything because maybe they already done the work. Some of the aspect they already done themselves, so they call me for a specific aspect of it. But what I like to do usually is really to do from A to Z. So that's where you really go with the CASP and really do the entire work, and not taking the work from somebody else is always more tricky and take time a bit to adapt. So I prefer to do, of course, the full part, but some of them, they just need to know, for instance, what is the right jurisdiction. So this is also the step to know if you want to comply. So this might be just one mission that we might have, but again, I would prefer to do the strategy development, then the talk with the regulators, then the jurisdiction selection, and then the implementation project kind of management role as well. So it really requires, I think, a full aspect of different things that I actually love doing, and I have experience in different areas of those, and that's the most interesting, to really see the CASP from the beginning to the end. So yeah, that's in a nutshell what it takes.
Really great points. I'm also curious to know your thoughts about, because you mentioned, of course, when doing the gap analysis, to make a distinction also between the already registered CASPs in the EU, but also more traditional financial institutions like banks, because I think a lot of people overlook that fact as well in MiCA, that also traditional banking, electronic money institutions, investment firms, and so forth, that they also, there's a lot of opportunity for them as well to enter the crypto market. I'm really curious to also know your thoughts. Do you see, maybe starting with you, Lisa, do you expect, or do you see a lot of traditional financial institutions also moving into the crypto world?
Well, that's a question I asked 2 weeks ago during a forum actually in Monaco. We had a women in tech forum, and one part was about blockchain. So some of people from Luxembourg was there as well, and I was in. And I asked the same question because I already had some response to it from my personal experience, from what I see myself. But it was also good to ask this exact question to know from their perspective how they see the market from France and from Luxembourg. So my take on this is that if I would be a financial institution, it will make so much sense for me to do so. Because before, if you are, for instance, a bank, you have a client coming to you saying, okay, I would like to buy 200 Bitcoin. The chance that you will accept will be very low. So a lot of banks, they say, I don't know this. It's still a gray area. I'm not sure I will be able to reply to this request. Some banks did. Some banks were a bit afraid. But what will happen after MiCA comes into force end of this year for CASP is that all those financial institutions, they will be able to accept this request, basically. So it will be silly. I mean, the demand is here. It will be silly of their part to choose. I think if you have a new business model coming, if you have clients requesting the demand for you to actually accept it. So I think yes, and I already see some banks even in Belgium look, because I'm in Brussels, so I see also the Belgian market. So I see some banks moving towards to it. But what I will see is two different routes. So the first route is the bigger banks, such as for instance JP Morgan. They already worked on something internally, so they will work on technology to issue or to offer certain services, such as custody, for instance. But for smaller banks, or maybe with less budget or less reactivity to these changes, what they will do is they will hire a third party to do that. So, for instance, if a bank would like to to provide the custody of digital assets, they might not have the technology or the knowledge to do this right away. They already have clients in January asking. So what they will do, they will ask already a service provider that is already established in the space to provide this service for them, white labeling or whatever agreement they might have. So for those type of party services, it's a huge opportunity too, because they will be able to basically be the bridge between the traditional finance and the non-traditional finance for those banks. So I see the big banks that might work on it, that yes, they are already working on it, so it's not no secret. And for the smaller one, either they will start working on this internally right now, which I don't think they're doing because they're already a bit late. So I think the most logical way to proceed is to outsource this. So yes, I think they will be. And the response that I ask also from my fellow colleague in Luxembourg, they said the same thing. So the banks are also, they see this movement from financial institutions as well. Some of them, like I say, they are very loud, Societe Generale, for instance, or even JP Morgan. Some of them...
Well, they have I think a license, right? Already.
So they're just working a bit on their behind closed doors, I would say, and waiting for the right moment and the opportunity to just the market. So of course it's I mean, even without being in the market, it's logical. I mean, if you have demand for something and you're allowed to do so, what would be the negative, what would be the downside not to, you know? That's kind of the logical mindset that behind.
Exactly. Yeah. And what about you, Marcel? Do you see maybe other players in the market that are not traditionally active, or have not yet been active in the crypto scene or the crypto world, for instance, investment firms or others? Have you seen any other relevant movements?
Yeah, I'd actually wanted to elaborate on that, because I fully agree that, you know, some banks have been rather hesitant, and even now that they or will be allowed to provide certain services quite easily, actually, which seems to be quite an advantage. Not having the technological knowledge, you know, still provides some challenges for these entities. And so what I've been seeing in the DACH region, at least, specifically in Germany and in Austria, is you know, banks engaging with well-established VASPs and CASPs, and preparing deals to provide custody and Bitcoin services. I haven't come across anything more exotic than Bitcoin from a bank's perspective, but at least that's that. And I think in regions like Germany, for example, crypto assets have been under the Banking Act already. So it already had pretty high standards. So in Germany, I would say the step for banks to take, you know, basically reaching out to these service providers, was fairly logical and easy, because they have already applied such high standards to crypto custodians in Germany. In other jurisdictions, I think MiCA will really play out, because in jurisdictions that had weaker regulations and maybe only relied on AML regulations, registrations, there this really increases the compliance and the whole game for these CASPs, and even enable banks in these regions to collaborate with these CASPs that are now you know, being applied with similar standards, or, you know, at least higher standards than before, right? So in these regions, it may now be even an enabler for such collaborations, even though, yes, banks could also do it themselves. But I also see the problem that they haven't been investing too much into this. The only thing that I have seen banks doing is investing in Bitcoin. Not in Bitcoin themselves, but Bitcoin knowledge. So, I've seen a lot of workshops and, hey, there's this new thing, Bitcoin 2024, which is a bit ironic, but I think in the US, they are a little bit more advanced here. But I think we will see a huge increase in offerings. I think the Volksbank in Austria and in Germany have launched things, I believe, or at least are in preparation of. Now, these are local branches, if I'm not mistaken. So regional branches that are trying something and being more bold. And I think under MiCA, we can expect some banks even to go forward themselves and maybe even hire the necessary knowledge and technology long term. But short term, I fully agree, they will most likely rely on existing CASP. And again, my point being that MiCA here plays a huge role because it allows these banks to engage with more serious players than currently, where it's not clear what quality you get depending on the jurisdiction. And I don't want to change topics too quickly, but there's something I wanted to say a while ago when Elisa talked about, are you a CASP or not, right? And do you even need a MiCA license? I have engaged with, I mentioned that last time, with lots of clients who are currently operating out of third country jurisdictions, relying heavily on reverse solicitation. Some of these jurisdictions that you may have guessed already include the Seychelles, British Virgin Islands, Cayman Islands. Some of these jurisdictions, have been improving, especially when it comes to FATF gray lists, right? So some of these jurisdictions are not as bad as their reputation anymore and are definitely improving. And especially the Cayman Islands have some very great legal structures for DAOs. But that's a different story, right? But some of the questions that are currently being discussed there is, so how do we deal with the reverse solicitation prohibition, right? It's no longer, that's what they even specifically said, right? And when you look at it, it's really it's really no longer allowed, pretty much, right? Because basically it says that on their own initiative, clients from EU can reach out and let's say I want to do spot trades, so I specifically sign up to do a spot trade and buy Bitcoin. So that's fine, but now the burden of proof lies with the unregistered CASP to make sure that no further messaging receives the client in regards to other services, not even a newsletter. I would even say like any system messages could be even a problem, informing the client about a new listing, and about a new service. And so the burden of proof is really on the other end. Otherwise, they will end up on the blacklist as non-compliant CASP in Europe. And I think the long story short is, if you are relying on reverse solicitation, I think you should think about changing your business model and maybe invest the time that you are currently investing in trying to fit into that very narrow window. Maybe set up a local entity and try to apply for license. For some of these providers, it will not be an option, because when you look at their entity structures, it's not set up in a way that would allow you to receive any type of license in Europe. But I think that's also fair, because that's leveling the playing field. That's what MiCA was also about. For all the entities that are putting all the effort into it, all the money and all of that, to become fully compliant, I think we must find a way to ensure that it's fair and that people play by the rules. And I don't think we can continue like we have been doing with these third country firms basically approaching the market, right? In some jurisdictions, even quite aggressively. Now, you may ask, so how do we ensure that they will not do that? Maybe that's a question for somebody else. Like for me, I'm also still having some doubts. I believe that it's going to be quite hard on both ends. So from the non-compliant CASP to prove that there was no solicitation involved, and also to document basically every step that the client has taken, but then also for the authorities to identify these breaches, right? So that's a different part of the story, but in general, I think that's the right direction, and I think it's going to have a huge impact on the playing field in Europe, because as I said, and as we all know, reverse solicitation is basically, or has been, a business model, right? And these days, in my opinion, are gone. Of course, you could say we're just gonna bet on, we won't be caught, but I don't think that's a wise idea. Even if in the beginning there might be some chaos, but I think ultimately we'll figure things out in the EU, right? Maybe it takes a couple of years, but I think there's so much dedication to making it work, even though currently there's lots of criticism as to how and if it's even achievable. And we can also talk about grandfathering, but we only have 5 minutes left. But maybe I'm going to leave it at that. But it was something I wanted to have shared.
Yeah, I think a really, really interesting and valid point. Yeah, and yeah. Sorry, I interrupted you, Lisa.
No, to your point, Marcel, it's actually at the end of the day, you need to prove that the potential client solicits you. You need to have any evidence. If you have any, you need to have emails. You need to have basically a strong case. If you deal with European customer, that they reach out to you, even though maybe you met them on the street. Ask them, basically send me an email that actually you want my service and I didn't do anything to reach out to you. So this is one that you will need basically to have some proof. And if you have, of course, if you have a newsletter or even some marketing in Europe, or your website on a language from the European Union as well, it might be not a good indicator. So basically you would need to prove the point that you are not soliciting. And this is, of course, you have a range of different examples that we are discussing also internally, discussing, for instance, does putting a Twitter banner that you're working for a company and you put the company or motto or website in your Twitter banner is considered as soliciting or not. So this can become tricky because, of course, going to an event and do some marketing is quite clear. But I compare, so to put a banner on the Twitter, I compared is like wearing a T-shirt from that company on the street. Is it soliciting? I think if you go to an event talking about that topic, it is, because you are promoting the company in a specific context. But if you just put some socks or T-shirt of that company in Europe, would it be considered as soliciting if it's not in the context of a marketing event or a professional event, So this is, I think, this is still a gray area. In my opinion, if you are, of course, putting this T-shirt on Paris Blockchain Week, for instance, next week, then yes, of course, I think it's clear. But if you're on the street in Brussels wearing it just like this, is it? This is, I think, still up to interpretation. This will be, I think, will have the internet, especially now, you have a lot of different scenarios that they will need to be clear on. This is solicitation and this is not. So this is, I think, like you said, Marcel, a job for them to be very clear, and then for the market to know exactly what is the line, and not to be in this blurry situation where people actually don't know.
Yeah, I think it's interesting because the BaFin, for example, has had a case where I think they called out Uniswap for addressing the German market in one of their tweets. And if I remember correctly, maybe someone in the chat can post later on, but I think the tweet used some German flags. I believe it was written in German or English, I don't know, but it was basically just announcing their wallet that they have recently released, right? And this immediately triggered the BaFin to put out a warning that they are an unregistered provider without a license addressing unlawfully the German market, right? And I think when we look at how strict these rules will be enforced under MiCA, I think we can look at some of the more stricter regulators, such as the BaFin, but also in other jurisdictions where they have applied quite strict rules already. And I think they will continue to do that and are actually encouraged and allowed to under MiCA as well. So, but I think these edge cases that you've just mentioned, I think I've seen thousands of blog posts of lawyers and others discussing this. And I think ultimately, as always, it always comes down to enforceability. and on which cases the regulators will focus on. And I don't think they have the resources and money, to be honest, to do that. They will need to do increased hiring, and it's even currently debatable if they can handle all of the 2,000 plus CASP applications for a MiCA license. In time, on time, I don't know which one is correct, but yeah, let's see.
No, indeed, yeah, and I think looking at the time as well, I think we had the same challenge during the last roundtable. There's so many things we can talk about. I wanted to touch upon DORA as well, and many other interesting topics. And maybe just to wrap up, Marcel, any final thoughts you would like to share in regards to the practicalities of implementing MiCA?
Yeah, I think don't be overwhelmed, and make sure you not only train external lawyers and consultants, but also your own people and your own employees. Make sure that that people in your company, employees, understand the implications, not only compliance, not only the silo working on it. Same with anti-money laundering. Make sure it's understood by a broad scope of people within your company that may or may not be affected, and try to not disclose it to them like a lawyer, but try to translate a little bit and make it more feasible and understandable. And that way you will save a lot of money, because ultimately we've been only talking mainly about getting a license, but the other thing is actually maintaining a license. And that means all of your employees need to be on board and need to follow on compliance. Otherwise, it's all for nothing.
True.
Yeah.
Lisa?
Yes, and to your point, Marcel, yes, practicality. It's depending with whom you're talking to, of course, it's really important to understand for your business actually what MiCA means, not what MiCA is, what are those requirements, what are those 160 pages, but what does it mean for your company, and to which extent the work needs to be done for you. And that will give you an indication of how much months, weeks you will need to into work for you to be compliant. So I think really what MiCA, what does it mean MiCA for you? That's the first thing to know, and then to start to have a strategy to understand those gaps and then implementing those gaps. So if you need to do things in order, that would be the best way to do, I would say, for general audience.
Exactly. Yeah. Unfortunately, we came to the end of this session. So again, thanks, Marcel, Lisa, for sharing all your insights and expertise. For me, at least, it was absolutely wonderful to have you as table guest for a second time. So that means a lot. So while we're ending this discussion for now, we're absolutely available for further questions on MiCA. So for the audience, please feel free to contact either Lisa, Marcel, or myself directly for any personalized guidance for your organization in regards to MiCA implementation. And of course, we hope you enjoyed the conversation again. And we look forward to seeing you at our next Compliance Insight Roundtable. For now, thank you and bye.
Yeah, thank you, Marcel, as well.
Thank you.